Thank you, Your Excellency. This case management conference is in regards to case number CFI 073-2022 is being held by way of video conference before His Excellency Justice Nasser al-Nasser. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Al-Tamimi and Company. Lead counsel is Mr. Timothy Killen. The first defendant is represented by HFW Middle East LLP. Lead counsel is Mr. David Walsh. The second defendant is represented by Kennedy's Dubai LLP. Lead counsel is Mr. Neil Hex Casey. Would the judge and counsel please confirm that the situation is as I have stated?
It is, thank you.
We may start with the claimant.
Fantastic, thank you, Your Excellency. I appear on behalf of the claimants, and Mr. Walsh appears on behalf of the first defendant, and I believe Mr. Neil Hext KC, who has Mr. Fir Segal, appears on behalf of the second defendant, the broker. Your Excellency will hopefully have seen from the skeletons and from the case management information sheet and the agreed case memorandum that this is a case concerning a claim on 3 insurance policies in respect of COVID-19 related business interruption loss. The allegation is essentially that there are 3 primary coverage clauses which would respond to the business interruption loss on behalf of the claimants as against the first defendant insurer. And there are 2 primary allegations made against the defendant. First, that they didn't manage to obtain cover under what's called the closure clause in respect of closure as a result of infectious or contagious diseases. And second, we say that they have exposed the claimants to the unnecessary risks, and in particular a risk of litigation in any event. Even if that clause responds, we say there's ambiguity which has caused the claimants to be exposed to unnecessary risk. There are, as a matter of case management, I think 2 primary matters that need to be determined today. The first and the most meaty of the matters is whether there ought to be preliminary issues ordered. And then the second is to set directions to any trial or to any trial of preliminary issues. Your Excellency, would it make sense if we started with the preliminary issues point first? Thank you. On the proposed preliminary issues, the first defendant has proposed preliminary issues. They are at page 84 of the case management bundle. They start at 1. One can see that these are all directed to the interpretation of the customer extension clause, the closure clause, and the loss of attraction clause. It may be worth running through them very briefly, because one of the points we make is that there are quite a lot of them and there would be quite a lot to get through. On the construction of the extension clause, 1.1.1, that's the second paragraph from the bottom of page 84, is whether the concept of loss or damage relates to physical loss or damage only. 1.1.2 is the question of whether the requirement for loss of damage is satisfied by a closure order, and that then refers to particular types of order that were made for COVID-19. Now, we do say that this is important because we say that would require the court to have some background information, facts and understanding of the type of orders that were made and the type of directions that were given by various authorities at the time. There is also a question of whether the closure or the loss or damage is satisfied by the sealing off of a customer's premises. So this clause is the one that we say responded as a result of people being told to stay at home and therefore being unable to go out to restaurants and shops. 1.1.3 is whether the term customer extends to a retail customer who have habitually attended the claimant's premises. So whether it is enough for the insurers simply to identify that there were fewer people coming to their shops, or whether they would need to identify particular people. 1.1.4 is whether those particular customers need to be identified. So whether they need to show which customers didn't attend, or whether it's simply a matter of there being fewer customers generally. 1.2 is the closure clause, which again, oh, I'm very sorry, I think there's a feedback on the line. I wonder if somebody could mute.
It's okay.
Wonderful. 1.2 is the proper construction of the closure clause, and that is at 1.2.1 a question of who the relevant order needs to come from, whether it's the National Health Authority, competent government, or public or statutory authority. Now, pausing there again, we say that this is another issue that would require a relatively involved amount of background information and fact. It may be capable of being agreed, but one doesn't really know yet because that hasn't been proposed. One needs to know the character of the alleged authority that's making the order in order to be able to argue whether it falls within the correct definition within the clause. There is then a question, 1.2.2, of whether the clause ought to be rectified to include the words infectious or contagious disease. Now, Your Excellency may have seen on the skeletons and on the pleadings that there is a clause, the closure clause, which includes the words infectious or contagious disease in the heading to the clause, and also in the schedule to the clause, but doesn't include those words in the body of the clause. And the claimant's primary case is that the clause is to be interpreted as including cover for closure as a result of infectious or contagious disease. But on the alternative, there is a claim for rectification, so that the court ought to correct the contract. Now, again, pausing there, 1.2.2 and rectification, that is a question, that is a cause of action that requires fact, because it requires proof that there was an agreement for there to be that language in the contract. We do say that if this rectification issue is going to be run, that there would need to be witness evidence disclosure, and this is likely to be contested fact as well. 1.2.3 concerns the question of what needs to be proved within the particular radius, so within the 2 kilometres of the insured's business. And then finally, 1.3 is the construction of the loss of attraction clause. So whether it is limited only to a specific local incident where the police or a statutory authority seal or close up particular premises, or whether it responds to a national or regional governmental response. So again, that's something that would require the court to know first what the particular closure orders are that are being relied on, what the nature of those orders are, and two, something about the body that's giving the order, so that a determination can be made as to whether that is an order that falls within the loss of attraction clause. So those are the preliminary issues proposed by the first defendant. One can see at 2 to 8 the directions that are proposed for a preliminary issue trial by the first defendant. Your Excellency may have noted that there is no provision there for any agreed or assumed facts or any witness evidence or the like, and that is something that we say is important in this context. The second defendant's preliminary issue is just moving on a bit in the bundle at page 87 under 1, and it's at 1A, and it refers back to paragraphs 43 and 44 of the particulars of claim, and whether the closure clause on its proper construction includes an indemnity in respect of infectious or contagious diseases. Now, those two paragraphs, 43 and 44, are concerned with how that clause is to be read and whether the fact that the language in the body doesn't include infectious and contagious diseases is something that ought to be read in such a manner as though those words were included, or whether they are otherwise to be included because of the background fact and the like. Now, the one thing we do note is that, as I raised with Your Excellency just now, there is a secondary case concerning the closure clause and whether the infectious contagious diseases language is included, and that is rectification. And interestingly, what the second defendant doesn't propose is that the rectification claim ought to be heard with it. And Your Excellency may have seen from the skeleton of the second defendant that is likely, I think, reading between the lines, because rectification would involve, and the second defendant does accept this, some witness evidence and factual evidence. Now, pausing there again, we do say that in the context of preliminary issues, it is unusual, or it would be unusual, for two such closely related issues to not be heard together. But of course, the reason for that is that in this case, that second issue that is naturally, we say, heard with the first issue, so interpretation or rectification, we say would be most efficiently heard together, is likely not being put forward because the second defendant has realised precisely and appreciates precisely that it would involve some factual dispute and therefore isn't naturally something that might be a preliminary issue. So, Your Excellency, those are the preliminary issues that are proposed and some of the initial points that arise out of it. I set out in my skeleton argument some guidance from the English court with reliance on the case of Aldersgate and Ham Construction, which is a decision of Mr. Justice Aikenhead in the Technology and Construction Court. It does refer to other decisions from other courts, including the decision of Steele and Steele from Mr. Justice Neuberger, as he then was. But perhaps if we could turn to page 119 of the bundle, which is paragraph 16 of my skeleton argument. And it sets out there, for Your Excellency's note, the case report of Aldersgate and Ham Construction is behind the skeleton at page 125. But starting first of all with the guidance, we say that the knockout, or the primary point, sorry, that's to be considered in the context of preliminary issues was that set out by Aikenhead, quoting from the House of Lords decision in SCA Packaging. That's quoted at paragraph 9 of Aldersgate and is below paragraph 16 of the skeleton argument. And that provides that the essential criterion for deciding whether or not to hold a pre-hearing, but I think it's accepted that's a reference to a preliminary issues hearing, is whether there is a succinct knockout point which is capable of being decided after only a relatively short hearing. Now, there are then 10 factors that are listed in Steele, which are set out at 17.1 to 17.10 of my skeleton. But as Mr. Justice Aikenhead notes, those are not, that is not an exhaustive list, and others might be added. And to that, Mr. Justice Aikenhead considered in the Aldersgate decision that the agreement of the parties was something that was relevant. We say also, logically, it's the case that not all of those factors are relevant in every case. And I have drawn out at paragraph 26, 4 of them that we say are particularly relevant. However, starting with the essential test, so the primary way that it was put by the House of Lords in SCA Packaging, we say that neither of the proposed preliminary issues are what would be referred to as a knockout point, so a point that would determine the litigation and bring it to an end. Now, we say that in respect of the preliminary issues proposed by the first defendant, because what they essentially go to are the interpretation of the clauses But then, of course, once the clauses have been interpreted, there will still remain claims under those clauses. It's simply a matter of whether what has to be proved can be proved. Now, we say that there are vanishingly few likely outcomes of those preliminary issues where the claim would not continue as against the first defendant. And that, we say, is important, where the second part of the essential test is whether it can be decided after a relatively short hearing. We say that, in fact, as Your Excellency will no doubt have appreciated, there's quite a lot to get through on the first defendant's preliminary issues. The first defendant has proposed 2 to 3 days in their case management information sheet for that hearing. I think in my learned friend's skeleton argument suggests 2 days. We say realistically at least 3 days, and likely we would say 3 to 4 days. Listing safely, one would say probably 4 days of court time. So we're already nearing a week just on the preliminary issues alone. So we say that can't be considered a relatively short hearing. We also say that because time is clearly something that is important, that we say that essentially having what is nearly a week's trial, a 4-day hearing, by the first defendant's directions November of this year, that would cause considerable delay in circumstances where the case is almost certainly to continue against the first defendant in any event, because essentially the court would be listing one trial. We would have directions to that trial, have the trial itself in November, and then the parties would need to reset and start again. And we say that really, realistically, we wouldn't be looking at a resolution of this case until well into 2024, possibly into 2025. Now, on the second defendant's proposed preliminary issue, we accept that the time required to determine it would be shorter. It's said to be a day or less by the second defendant. Again, probably listing cautiously, one would say 1 to 2 days, particularly as there are likely to be 3 parties involved. These things are probably best given a little bit more time than a little bit less time, so that the issues can be fully ventilated. So we don't take issue with the length of the hearing that would be required for the second defendant's preliminary issue. But what we do say is, again, it is unlikely to be a knockout point. And the reason for that is that, as I set out at the outset, there are 2 points made against the second defendant. The first is the failure to obtain the wording that included infectious or contagious disease cover. But the second is this exposure by the second defendant of the claimants to unnecessary risk. And we say that that claim would not be determined. We also say as well that it would be an unusual scenario for the interpretation arguments to be determined on closure by reason of infectious or contagious diseases, but for the rectification argument not to be determined with it. And I've covered that already, but in essence, we say it would be most efficient for the 2 to be heard together. But the rectification argument requires evidence, requires witness evidence, and probably contested facts. And so if one has that, then one has a situation where actually rectification is not, and I think this is recognised by the second defendant, suitable for a preliminary determination. And so it's being split, which we say again is inefficient. So we say that neither of the preliminary issues proposed, or neither of the sets of preliminary issues proposed, gets past this primary test. So whether it's a succinct knockout point that is capable of being determined at a relatively short hearing. We say, in essence, that there would be a likely increase of time and cost as a result of these preliminary issues, because in essence, what would be happening, especially against the issues proposed by the first defendant, is that there would be two trials, they'd be split, and whilst some issues, and we agree, could be resolved as to the interpretation if the first defendant's preliminary issues were being heard, it would be the case that then the parties need to essentially gear up and run towards a second trial. So any saving that might be made by being able to direct the factual and the expert evidence towards the actual interpretation that might be found by the court, we say would be significantly outweighed by the delay in time that would be caused by having a preliminary issues trial followed by a second trial, and also by the additional cost that would be involved that would necessarily come with time. Another factor as well, and my learned friend, I think Mr. Hext for the second defendant, has pointed out that there have been preliminary issue approaches taken by the English court and I think also the Australian court to COVID business interruption insurance cases. Now, we say those primarily are in a different context. They are, or at least some of those, the FCA decision, the Marrickville decision in Australia, were in the context of providing some guidance in an area where there was no guidance. And so it made sense for there to be preliminary issues that had a wider application. Now, there's no suggestion of that here, but in any event, as a common law court, this court can take account of the guidance already given in those other cases. But the second point that we make is that most of those decisions that were listed by my learned friend were decisions that were appealed. And that is something that one needs to take into account here as well, is that on the construction points, there may well, and we say likely, be an appeal. And likewise on the issue proposed by the second defendant as a question of interpretation. And that again is something that needs to be taken into account in the consideration of how long this is going to take, because if there's going to be an appeal, that of course inevitably creates further delay. And we would certainly then, we say, be looking at 2025 for the conclusion, for the final trial of this case, and probably deep into it at that stage. We also say that it is important where one has a number, and one can see how involved and detailed the questions of construction are from the way that the first defendant has listed those preliminary issues, proposed preliminary issues. We say that in circumstances where one has detailed questions of construction, it is preferable for those questions of construction to be dealt with not against assumed facts or agreed facts, but dealt against the actual facts of the case. So for the judge to have heard the particular evidence of what has happened and what has gone on and how the claimants have suffered loss, and then to make a determination of the meaning of the policy against those facts rather than simply in a vacuum and in the abstract. And then finally, we note as well that this isn't a case where there's agreement of the parties. And we say that's important because that is one of the factors that Mr. Justice Aikenhead identified, that where there was agreement of the parties, the court should take that into account. But that also suggests that even where there's agreement of the parties, the court needs to be careful in approaching it to make sure that its time and resources are used efficiently. We say that there's no agreement here, and that is a factor the court can take into account against. So, Your Excellency, for those reasons, we say that the preliminary issues proposed by the first defendant and by the second defendant would not be an efficient use of court time or resources, or indeed we say party time or resources. And for those reasons, we suggest that the most efficient thing to do would be to list this for a full trial, likely in the region of, I think, 6 to 9 days is the range. So within 2 court sitting weeks, when all matters could be determined at once. Unless I may assist Your Excellency further, those are my submissions on the preliminary issues.
Thank you. First defendant.
Your Excellency, thank you very much. You've seen the clauses and the preliminary issues that we're talking about here, so I'm not going to go over that again. I wanted to just start, though, by explaining why, at a very high level, we are proposing preliminary issues in this case. And the reason is to try and make this case manageable for the court. We have a large number of claimant entities that are identified in the schedules to the claim form, at least 8 of which seem to us to be bringing claims. So we think there are 8 claimants bringing multiple claims across various different locations. Those claimants are based in a number of jurisdictions: Bahrain, Kuwait, Oman, and the UAE, and the claimants have prayed in aid regulations across all of the regulations, announcements, and restrictions across all of those different jurisdictions, none of which are common ground at the moment. The claimants have also suggested that they will be calling expert evidence from an epidemiologist, apparently, on the incidence, timing, and location of cases of COVID-19. And there is a very, very substantial quantum exercise which would need to be conducted, which it looks like the claimants are yet even to begin. So taking a step back from all the detail, the reason behind the suggestion for preliminary issues, at least from the first defendant's perspective, is to try and make this case manageable, to narrow points down and to try and focus on what might really be in dispute at the end of that. Now, the second defendant has obviously proposed a slightly different course in terms of preliminary issues, with a single preliminary issue. But it seems from, and without wishing to put words in my learned friend's mouth, it seems from my learned friend Skeleton that there's not serious resistance to expanding the scope of the preliminary issues, at least in the way that we've proposed. Perhaps there's an issue on rectification being within those, but I'll let him speak for himself. But anyway, certainly the defendants seem to be of one voice, which is that some form of preliminary issue or issues would be appropriate in this case to try and make it more manageable for the court. And we've identified in our skeleton a number of reasons, and I just want to expand on those now as to why we think this is a particularly good case for preliminary issues. The first point is that virtually all the preliminary issues that we've proposed, all bar one, are pure points of contractual construction, which are essentially going to be the court looking at the clause as against the background of the pleadings and saying, what does this mean? And those are classic examples of matters which are appropriate and often ordered as preliminary issues. The second point we make is this: the preliminary issues can, we say, be determined swiftly and at relatively minimal expense to the parties. Now, my learned friend has tried to suggest that actually we may need more than 3 days to argue about these points. We say that simply isn't realistic. In the main, we are dealing with relatively short points of what does this clause mean. Contractual construction, where there will be no extensive disclosure required, no factual evidence, and no witness evidence at all. It's simply the court ascertaining on the language used, what does this mean? And we say that that is not a lengthy exercise. And counsel can often over elaborate these points, but actually with a bit of discipline, it should actually be capable of being resolved within 2 days. There may need to be some reading time on top of that, but that's what we say is a realistic assessment. We also say that the claimant's suggestion that actually you would need more than 3 days for these issues is unrealistic, given that they suggest the whole trial could be disposed of in as little as 6 days. And that would be including all of the disputed evidence of fact, all of the quantum evidence, all of the expert evidence. And if that's going to be resolved in 6 days, a minimum of 6 days, but 6 days is apparently said to be achievable, how can these narrow points that we're asking for preliminary issues on require 3 days? It just doesn't stack up. So we do say a 2-day hearing plus some reading time would be appropriate for determining these preliminary issues. And that could provide a real shortcut. Now, points have been made about the fact that we haven't got an agreed statement of facts, and that may mean that oral evidence is going to be required from witnesses. We don't accept that. Certainly on the points of construction, there can be no possible need for witness evidence. It would be inadmissible evidence about what people thought about what clauses meant. Conceivably, one can have factual evidence on factual matrix points, but there is no pleaded factual matrix as to the meaning of these clauses. So we don't see where the witness evidence would go on that. So we do say that when we're looking at the points of construction, we are engaged in an exercise where there will be very little, if any, effort required to identify the relevant facts to determine them. They can proceed to determine, the court can proceed to determine those without an agreed statement of facts, and determining those without an agreed statement of facts doesn't actually impinge on the value of the preliminary issues. Now, if there really is a separate point about rectification requiring some oral evidence, well, then we're happy to proceed simply on the points of construction as preliminary issues. We recognise that if that is going to be something that my learned friends will call oral evidence on, who said what to whom when, then that can be carved out. But that's really going to be a matter between for those parties. We say the rectification is really going to be determined on the contemporaneous documents rather than the witness evidence. The third point we make is that of course we don't suggest that the preliminary issues would be dispositive of the case as a whole, would definitively be dispositive of the case as a whole, but that's not the relevant litmus test. My learned friend's taking you to the guidance given by Mr. Justice Neuberger, as he then was, and the question is whether the preliminary issues will dispose of at least part of the case, and in this case they would, we say. In terms of the claim against my client, the claimants say that they will continue that claim even if they lost on all the preliminary issues, but it would be very difficult to see how that claim could continue if they did lose on all the preliminary issues. And then in terms of the claim against the second defendant, if we lose on the proper construction of the closure clause, such that it in fact provides cover for infectious diseases, then the claimant's claim against the second defendant for an equivalent indemnity from the second defendant would fall away. Now, the claimants say, well, we're going to continue against the second defendant regardless because they exposed us to unnecessary risk, i.e., although they got the cover they were supposed to, they didn't get it unambiguously. But that is a claim of a very different character. I'm sure my learned friend, Mr. Hex, will elaborate on this. It's a very different character and a far lower quantum claim than the one that would be considered otherwise. And to all intents and purposes, the claim against the second defendant would fall away in those circumstances. So the preliminary issues have the opportunity to really narrow the case and for substantial disputes to fall away, along with all of the factual and expert evidence that would be required to resolve them. We recognise that if one then proceeds after the preliminary issues to a second trial, there is going to be some delay, but of course the extent of that delay really depends on, firstly, how quickly the court can list the matter, or secondly, whether the parties may in fact seek to try and resolve their disputes after the resolution of the preliminary issues without troubling the court. But if there is to be a second trial, we reject the idea that costs will have been wasted. That second trial would be a much more focused trial because of the disposition of the issues by the court first time round. And we say that it would be effective even in those circumstances. The final point, Your Excellency, that I would like to make in this regard is this. If there isn't going to be a trial of preliminary issues, what is going to happen? Put another way, how can there be a trial of all the issues when the claimant's case on quantum is essentially non-existent as the matters stand? If we could just turn to page 31 of the bundle and paragraph 58 of the claimant's pleading. This is the entirety of their case on quantum. The claimants will, in due course and subject to the permission of the court, set out by way of expert evidence the quantum of their losses as fall to be determined pursuant to each insuring clause. Without prejudice to the foregoing, the claimants aver that, save in respect of the claims preparation cost clause, their losses combined exceed the limits applicable to each insuring clause under which a claim is made. That's it. There's nothing more. Now, what the claimants suggest in their suggested directions is that the parties' quantum experts are going to get together in November, or are going to prepare by November their expert reports on quantum. Now, my learned friend's expert, so the claimant's expert, will prepare his evidence. But the first we'll know of what their case on quantum is when we see that expert report. The claimants are proposing that we serve our expert evidence at the same time as they serve their expert evidence. What's our expert going to be saying about all of this? He's going to say, well, all I've got in terms of an indication on quantum is paragraph 58, which is, you'll find out our quantum when you see our expert evidence. So an experience of these cases suggests that the quantum disputes are very, very significant and very detailed and involve very difficult calculations performed by forensic accountants. So it's all very well saying, well, we're going to have a full trial of all the issues, including quantum. But how practically is that actually going to work in this case? And we just don't see it. Now, it's fair to say that the experience in England after the FCA test case has often been for policyholders to file fairly vague claims when it comes to quantum. But in fairness to those policyholders that do that, they are normally the ones seeking the preliminary issues. And the commercial court in London has ordered preliminary issues in numerous cases: Stonegate, various eateries, Greggs, Excel. There are then some 6 claims on preliminary issues going to trial in October on a different set of provisions. And some of those claims, the quantum is equally vague, but that's because the policyholder is saying, look, let's resolve the coverage points first and then come back to quantum later. So that's understandable. What makes this case somewhat unique, I have to say, is for a policyholder to say, we've no idea what we're claiming. We haven't got a figure we can tell you. We can't tell you how it's broken down, and we don't want to trial of preliminary issues. We want to do quantum as well, all at the same time. It's just you won't know what our case is on quantum, so you won't be able to grapple with it. So we say that that's not sensible. And so and against that background, this isn't just a case of, is it just and convenient for preliminary issues? Actually, splitting the trial up in this way is the only way to proceed, given the way that the claimants have chosen to present their case on quantum. So for those reasons, Your Excellency, and unless I can insist you on any particular points, we would invite the court to order preliminary issues. If there is some particular issue on rectification, which means that that needs to be carved out from what we've proposed, fair enough, that can come out. But let's determine all of the construction points first, and then when the claimants have got their house in order on quantum, we can come back and talk about that on a later date if they ever get there. Those are my submissions.
Thank you. Mr. Ext.
Your Excellency, thank you. Our submission is, follows a very similar path to the submissions that you've heard from the first defendant. We say that this is a paradigm case for a preliminary issue or for preliminary issues. The claimant's claim primarily rests upon the answer to a relatively small number of points of construction in relation to the policies. And these are key legal points, can be dealt with without any oral evidence or substantial documentation. As Mr. Walsh has already mentioned, this has been done very successfully in the context of business interruption COVID cases in other jurisdictions in the UK and in Australia. Mr. Killen says, well, that's because those are test cases and they're providing guidance. Well, yes, they were providing guidance, but also it's interesting to see what followed on from those test cases, because the FCA case resolved a very large number of points of construction, and essentially that cracked a large proportion of the cases that were on those types of wordings. One didn't see continuing litigation about the claims that the underlying policyholders had against their insurers. Those are simply adjusted and then they were settled. So this approach is one which is tried and tested in other jurisdictions. We would say that it's a sensible approach. On the specifics of this case, once these issues are resolved, we say that there is a good prospect that it will resolve the case as a whole. Yes, we accept that there will be issues that will still be live, but because of the narrowing of issues between the parties, it is likely, we say, that there will be a degree of settlement, and we say, as far as the second defendant is concerned, it seems very unlikely that this claim will proceed against the second defendant if the court finds that the claimants are right on the construction of the closure clause. Now, but even if it doesn't resolve finally all of the issues, we adopt what Mr. Walsh has said about how it will significantly narrow those issues and allow a properly focused trial to take place on the underlying factual matters that give rise to the claims. And Mr. Walsh has already made the point about how complex the remainder of that case is going to be. Now, just then focusing on our position as the broker, what we say, I mean, we support the idea of preliminary issues here, but we say that the point that we are concerned with is even more straightforward. Indeed, we are something of a bolt-on to this litigation because our only involvement is in relation to the closure clause, and it's perhaps worth just turning up what that clause is about. It's at page 12 of the bundle. And you'll see that it's at the bottom of the page, 6.11.2 sets out the heading for the clause, which includes the phrase infectious or contagious diseases. And then the body of the clause, if you go to the top of the following page, you will see that there are a number of causative factors that could give rise to closure that are mentioned: manslaughter, murder, suicide, vermin, etc. But they do not, infectious or contagious diseases is not mentioned there. And the construction point that we're dealing with here is literally, was the phrase infectious or contagious diseases omitted as a result of an obvious mistake? The court will need to look at the policy as a whole in order to determine that question, but probably no more than that. No one has pleaded in this case that there are other matters of factual background that impact on this question. It's a question of pure construction, and it really is a very short point. I've said a trial of a day. I would be surprised if we spent as long as that, frankly, on it. Mr. Killen tells you that it might be 1 to 2 days, but I've seen these points being argued, these COVID points being argued, and really there is a limit to what you could say about these points of construction. We say that it will not take more than a day. Now, as you know, the broker is blamed for the omission of those words. If the claimant is right on the construction point, then the principal claim against the broker just simply falls away. So you'll have seen from the particulars of claim, there's a claim for 25 million dirham against us, and that is essentially the indemnity that they say they would have got from insurers had the clause been on their case properly drafted. Now, if they're right on the construction of the clause, the entirety of that 25 million dirham claim falls away, and we say it's likely to mean that the entire claim against the broker will also fall away. And it really is as simple as that, we say. Now, what are the objections that the claimants make to it? Well, first of all, they say, well, hold on a minute. This is not a knockout blow against the broker, because we've got a residual case that deals with, that says, well, even if we're right on the construction of the closure clause, because the clause was not satisfactorily drafted on their case, because of that, there's been a need for unnecessary litigation, and you, the broker, are responsible to us in respect of management costs and legal costs, etc., etc. And we can see the way that is. It's probably worth just looking up how that's pleaded by way of damages. Page 31 of the bundle, and it's at paragraph 61, right at the bottom of the page, under Article 145 of the contract law. They claim damages. over the page, you can see 61.1 is the claim for the 25 million dirham. 61.2, here we have the claim, the residual claim, if I can call it that. Investigation, legal costs, management costs, costs of other advice incurred by the claimants in determining whether infectious or contagious disease cover was included in the policy, including the costs of presenting such a claim to the insurers and pursuing these proceedings. These costs are continuing and will be quantified in due course. Now, the first point we make about this is that no number is put on these costs. And what are these costs likely to be? What are we actually talking about here? We submit that we are probably talking about something which is very, very modest in terms of size. There will, of course, be legal costs of bringing a claim against insurers, but if the claimants win against insurers on the construction point, then they'll get those legal costs back from insurers. So the other costs that are not going to be compensated, such as they are, if there are any, are likely to be very modest. And if they are very modest, then that must mean that the likelihood of settlement is very high. And the court is entitled to consider the extent to which a preliminary issue will make a case easier to settle. So realistically, the point will be dispositive if the claimants win on their construction of the closure clause. The second point that's made against us is, well, costs won't be saved. Well, our response to that is it depends upon the court accepting the claimant's argument that the claim against the broker will nevertheless go to trial. And for the reasons I've given, there's a strong likelihood that it won't. Even in relation to the claim against the first defendant, if we're not there, then the trial is going to be very much cheaper and probably shorter. And one has to bear in mind, and this is a point which Mr. Walsh makes, the trial of this claim is going to be no small thing. When we look at it as a whole, it will involve obviously disclosure and witness evidence, but we're looking at expert evidence as well, not just on the quantum, which, as Mr. Walsh tells you, has not actually been particularized at all yet, but also the question of the degree to which COVID impacted in a number of different jurisdictions. So we're going to have expert evidence on that. There's the question of what are the various rules in the various jurisdictions. So we'll need to look at all of that. And if we're right on broking evidence, which is a point we're going to come to in a moment, if we were at the trial, there would be the broking evidence, expert evidence as well. And we say that this is a trial which is going to take up to 9 days to deal with. And there's a substantial chance then of reducing significantly the cost of all of that. And there's also that other point, which perhaps is a small point, but it's this, that the residual claim that's claimed against us, i.e. the costs and the management time, that's all increasing the longer you leave over this question of what the closure clause means. Essentially what the claimants are saying here is we're going to have to spend a lot of money resolving what the closure clause means, but they're resisting a preliminary issue that would actually deal with that question in the cheapest way. Then the claimant says, well, it will cause delay. It won't cause delay as far as the second defendant is concerned if it's resolved in the way that I've described. A second point is made that, well, there might be an appeal, but that's a risk that exists with whatever you do, whether you order a preliminary issue or whether you say it should be a trial of all issues. There's always going to be a risk of an appeal, and that appeal is going to cause further delay. And the case, even if we have a trial in the early part of next year on everything, we could end up with an appeal from that, which will then take further time to resolve. So we say that is, although it's a factor, it's not a strong factor. it then says, well, then said, well, there's a lack of agreed facts. Now, in relation to this, we're a bit surprised to hear the submissions from Mr. Killen about how there's going to need to be lots of factual investigation into, for example, how things actually happened with the pandemic. Because, of course, we're looking here at a question of construction of the contract. Everything that happened after the contract was entered into is irrelevant as far as the construction is concerned. You won't need to look at these questions of what actually happened in the context of the pandemic, how the various governments responded. So there's an element of one has to keep one's eye on the ball here in relation to what's actually in issue on the preliminary issues. Now, Mr. Killen made the point that on my formulation of the preliminary issues, well, rectification will be left over. And he says, well, the question of construction and rectification go hand in hand and therefore ought to be dealt with together. Well, of course, the question of what the clause means can't be, it isn't a completely divorced question from a question of rectification, but they are nevertheless separate questions. The question of what does the clause mean is a question of construction. It involves looking at what the contract says. The question of rectification uses the construction of the clause as a starting point. One then has to look evidentially at the question of what the subjective intentions were of the parties to the contract. And that is a very different question and a very different focus. And that's why we've suggested that it be hived off to the main trial if you are with us on the question of preliminary issues. So for all of these reasons and the reasons given by Mr. Walsh, we say that this is a paradigm case for preliminary issue. At least as far as the second defendant is concerned, it's a very short point of law at the absolute heart of the case against us. If it's resolved in the claimant's favour, the claim against the second defendant will probably fall away, and the preliminary issue can be dealt with quickly with minimum preparation and a hearing of no more than a day. That's all I wanted to say about preliminary issues, other than perhaps simply to add that we are, of course, happy with the preliminary issues suggested by insurers if you're minded to go for that more comprehensive approach on construction. The only point that we suggest ought to be left over to the main trial is rectification, because that will involve factual evidence. Your Excellency, those are all my points, unless there's anything else I can assist you with.
Thank you. Mr. Killen.
Thank you, Your Excellency. I will be as brief as possible. I have a few points to come back on. The first is that Mr. Walsh recognised in his submissions that the regulations are not common ground. And Mr. Hext picked up this baton and then said, well, actually, then they're not particularly relevant. They're something that went on after the clauses were drafted, and so therefore are not relevant to the interpretation of the clauses. Now, the point that we were making is that it's difficult to see how the court can determine the meaning of those clauses in the context of COVID-19 related business interruption loss if it's not done against the factual background of the regulations and the events in the pandemic. So if the court is being asked to determine, does a closure need to be a closure by a police authority, or does a closure, or can a closure be a closure by a mall authority or a local authority? Well, then the court needs to know something of the character of the local authority, the mall authority, before making that decision. If the court is being asked, can a stay-at-home order for customers, consumers that would have visited the claimant's premises amount to a closure under the customer extension clause, well, then the court will need to know a bit of background fact as to what the closure orders were in each of the particular jurisdictions. And so we do say that there are questions of fact, very real questions of fact, that are relevant to the court's determination of the issues, because it's the background fact against which the interpretations need to be made. The second point is on rectification. Both my learned friends seem to now be suggesting that rectification shouldn't be put forward. In fairness to Mr. Hext, he never suggested it should be. The problem with that, and that is a realistic, we say, recognition of the fact that rectification would require some evidence and therefore is not naturally suited to being a preliminary issue. But the problem with that is twofold. First, it leaves the meaning of the closure clause hanging, in essence, because one can't then determine whether the closure clause is in fact something that includes the infectious or contagious disease wording. And that is important, we say, as against the second defendant in particular, because the second defendant, if they lose on the suggestion that infectious or contagious disease wording ought to be read in as a matter of interpretation to the clause, well, then they're still in the trial for the purpose of the rectification claim. So we say that leaving the meaning of the closure clause hanging is undesirable. The second point we make is that it is an issue which is conveniently tried together with the interpretation point. And we say that that can and should happen at the full trial. The third point is that there was a complaint made, in particular by Mr. Walsh, about the fact that there is as yet no quantum evidence. It seemed to be implicitly suggested that that might be something that is a bar to resolution of these proceedings. Now, if that's the case, then we say the sooner the quantum evidence is produced, the better. Because if this case can't be settled until quantum evidence is out there, well, then delaying quantum evidence by having a preliminary issues trial and then getting quantum evidence later is only going to make settlement more distant and more remote. The other point we would like to make is that Mr. Walsh suggested that there was a problem here with the way that quantum evidence was proposed to be dealt with. Well, with respect, that isn't a complaint concerning whether preliminary issues ought to be ordered or not. That is something that is simply just picking up whether there is something that ought to be done on the directions so that the first defendant can have some quantum evidence to shoot at. And we say that probably is best resolved by simply having a joint meeting between the quantum experts first and then having the reports second. So the quantum experts can discuss, they can understand each other's positions, and then they can address it in their quantum reports. That isn't, we say, anything that is relevant to whether there ought to be a preliminary issue or not. Mr. Walsh also said in the course of his submissions that they have no idea what the claimants are claiming. Well, we say not at all. The claimant's case is set out that the claims exceed the limits of indemnity, and so the limits of indemnity are claimed. As to the particular submissions made by Mr. Hext in the context of the second defendant's proposed preliminary issue, we say that it's simply speculative to say that the costs of the unnecessary exposure to risk claim are so modest as to be essentially irrelevant. And we also say that it's speculative to say that that claim won't continue. There are costs and management time involved, and they may well be fairly significant. As to the point on appeal, Mr. Hext suggested that there will always be a risk of appeal. Well, that might be right in that there might be an absolute risk of appeal in all situations. But what we say is that an appeal is less likely if these are findings made of interpretation against findings of fact, because it may make no difference or the like. So we say if the court, in fact, makes findings on these issues and makes findings of fact, that an appeal will be less likely, or if there is an appeal, it will be more focused. So for those reasons, Your Excellency, we stand by our position that this case is not suitable for preliminary issues, and it will simply just cause more cost and more delay to the resolution of these proceedings. Unless I can assist further, those are all my submissions in reply.
Thank you. I have a question for the defendants. Why are the defendants suggesting later than November, not before November?
For Your Excellency, was that for a trial of preliminary issues?
Yes.
I think that was to cater for a stage for disclosure. Hang on a sec, if I just get the draft order in front of me. Yeah, so I'm looking at pages 84 to 86. We outlined the preliminary issues. There's a stage for disclosure in July, and then there is a gap. I mean, I'm not wedded to the November date, if that's the question your Excellency is really driving at. If there was availability for a trial before November, then there's no reason, if the rely upon disclosure is completed by the end of July, there would be no reason why one couldn't have a hearing from, say, mid-September, I would have thought, subject, of course, to the court's availability. But no, I'd say it was probably out of an abundance of caution, rather than because there needed to be that length of time before the preliminary issues needed to be decided. I don't know if Mr. Hext has anything on that.
Your Excellency, yes. We'd actually suggested in our order, page 88, at the top of the page, that the trial of preliminary issues should be no later than the 1st of November, and we would be content to see a trial of these issues in September or October, whenever the court can accommodate us, because we see it as being a very straightforward exercise to prepare for this.
I think I suggest that, or I decide that there should be a hearing on preliminary issues by subject to the court's availability, but no later than September. And I think it would resolve a lot of issues if, when interpreting the clauses relied on, then the case would be much clearer, yeah, all the way through the trial.
I'm grateful.
So,
Your Excellency, is that the preliminary issues that are proposed at pages 84 and 85, or
the both issues of the first defendant and the second defendant?
I'm grateful.
And I don't think it should take more than 2 days.
Your Excellency, I wonder will that include rectification or not, because that obviously makes a difference in terms of preparation, and there would need to be factual evidence in relation to the rectification.
The rectification, I think, would be on the trial, on the main trial.
And I think there is a matter of wording as between Mr. Walsh and myself in terms of what the issue is on closure clause, but I'm very confident that Mr. Walsh and I can resolve that. So we will, subject to Your Excellency's views, if we can put together a draft of that and provide it to you as an agreed draft.
You mean on the preliminary issues?
On the wording of the preliminary issue, there are minor differences which are semantic. They're not substantive. And we just want to have one issue on the closure clause rather than differently worded ones.
And share it also with the claimant before.
Exactly, yes. Well, we'll try and agree it with all of us. I'm sure actually that we should be able to agree it between us, because having resolved the question of whether there should be preliminary issues, we actually know what the issue is.
Yeah.
Your Excellency, thank you very much for the direction on that. I suppose two things spring to mind. The first is, I wonder whether it might be safest to list the trial as 2 days with a day in reserve, just in case. I do think that we might need to be going some to do 2 days, and it would be a real shame if it was split, if there were just that availability of running over. I'm grateful. The second point is the direction that it be heard no later than September. I just have in mind that, and we will no doubt come on to this, but there was a suggestion from the second defendant that we agree with, that there ought to be a schedule of agreed or assumed facts against which this is determined. That will take some time. to agree. There is then, of course, the natural holiday period in August, where I expect people might be away, and council's availability for, I think there might be 4 or 5 council on this, might be tricky. I wonder if we could aim for no later than September, but not perhaps make that an absolute requirement, so that there can be some flex if there is availability that might be more suitable, that might make it go into.
When do you suggest, Mr. Kieran?
Well, I think, speaking personally, I have some difficulties from September until December, but that shouldn't hold things up just because of me. But I expect that there might be others. I know there is a COVID BI appeal going on for 2 or 3 weeks in the Court of Appeal in November that I think some of my learned friends are involved in as well. I wonder if it might just be left open, but of course that there is we have your Excellency's direction that, or suggestion that this ought to be done as soon as possible, and of course that will be taken into account. But I'm just slightly concerned that if it's said no later than September and everyone goes to the registry and discusses, we end up having to come back to your Excellency and ask for extra time.
You know, I want this matter to be resolved as soon as possible.
Of course.
And in my view, it's a matter of interpretation of the clauses, yeah? And it shouldn't take so much time, even in preparing to appear before the courts. And my aim is not to delay the matter further. So to get this resolved with, then we can look at the main trial, if there was any, if the parties, I hope the parties settle prior to the main trial, but at least to know, yeah? At least not to delay the matter further. This is my concern only. So that's why I said September. But if the parties want it as soon as possible, but not in September and October, then we'll see the course availability as well. But at least to get it, to get this issue resolved with as soon as possible. This is my concern. Yeah, not to delay matters.
Understood. Perhaps we can put a recital in at the start, noting that Your Excellency has proposed that this is resolved as soon as possible, and of course that will be borne in mind by the parties in the registry when listing.
Okay, but I will not tolerate delaying for months and months. Or yeah.
Of course, understood.
Clear enough.
Very clear. Thank you.
Okay, this issue is resolved now. Now we move to the case management order.
Yes. I wonder if perhaps it makes most sense to look at the second defendant's case management order at page 87 and 88.
Mm-hmm.
It is probably that which is most appropriate. The difference, I think, between this and between the first defendants is the disclosure stage. I don't know if Your Excellency, I understood from Your Excellency's direction just there that because rectification is out, there may not need to be a disclosure stage on that. But I do think that there will be assumed or agreed facts, which I think is paragraph 2 of the second defendant's direction. And the 11th of July sounds reasonable to me. I'm not sure if my learned friends have any points to make on that.
No, we don't object to that, I don't think.
We're very happy with 11th of July.
Anything else?
I think so. Paragraph 3 would need to be changed to I think within 14 days is fine. So I think that's fine. But then obviously the wording of which shall be no later than the 1st of November will be taken out.
Yeah.
Paragraph 4, the length of trial, if we say 2 days with 1 day in reserve, was Your Excellency in agreement with that?
Yes.
I'm grateful. In terms of reading time, I don't know what my learned friends propose. I would have thought that if Your Excellency is hearing this, then Your Excellency or whoever the trial judge is would be grateful of, I would have thought, at least a day.
No, it's not me who will hear this application.
Understood. I would have thought, I don't know what my learned friends think on this, I would have thought at least a day of reading time would be necessary, but certainly it would be sensible to allocate it.
I think a day is adequate, isn't it?
I would have thought a day is fine.
Certainly. So then preliminary issue 2 days, 1 day in reserve, plus a day's judicial pre-reading. Trial bundles of 4 weeks. We are happy with that. I don't know if Mr. Walsh is also happy.
I'm delighted by that.
And Your Excellency, will 4 weeks suit the court?
Yes, it's okay.
I'm grateful. Skeleton arguments, 3 clear days. Again, sounds sensible. And then, yes, liberty to convene and costs in the case. So I think that probably covers everything. I wonder if I might just very briefly check with those instructing me. I have a message channel open to check if there's anything else.
While Mr. Killen's doing that, there was a further issue about a broking expert, but I suspect that's gone off because of the main trial, the preliminary issue point. So we can deal with whether or not there should be a broking expert if the thing doesn't resolve after the preliminary issues.
Fantastic. I imagine that following the preliminary issues, there might be a direction for a further case management conference and directions then given to the second trial.
Yes, definitely.
Wonderful. Would it assist Your Excellency if we, I know the preliminary issues are going to be tidied up and agreed between the 3 of us. Would it assist to have a full draft order, or is that something the registry will put together?
No, send us please the draft order you agree on with the dates so we can issue this order.
Fantastic.
Yeah.
Thank you very much.
Thank you.
Your Excellency, there is nothing further from my side.
Anything from the defendants?
Nothing from me.
Nothing from me. Thank you, Your Excellency.
Thank you.
Thank you very much.
Thank you.
Thank you.
Good morning.